I'm Pat Brown, and this is PwC's Tax Insights in Brief. The United States Supreme Court on June 28 released its opinion in Loper Bright Enterprises v. Raimondo and Relentless Incorporated v. Department of Commerce. These two decisions together overturned the Chevron doctrine, which compelled federal courts to defer to a federal agency's reasonable interpretation of an ambiguous statute. Now, in brief, what the court held here is that the Administrative Procedure Act, or the APA, requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts are not obligated to defer to an agency interpretation of the law simply because the statute is ambiguous. Now, the majority opinion emphasized that its holding today does not call into question prior cases that were decided in reliance on the Chevron framework, and the holdings of those cases with respect to specific agency actions are still lawful, including, of course, the Chevron case itself. So those are still subject to the court's general, what we call stare decisis, or adherence to precedent, despite the court's change today in interpretive methodology. The majority opinion also noted a couple of caveats that are worth calling attention to. One, the judgment of executive branch agencies, which are, of course, in many respects the subject matter experts in these areas, can be referred to by a court in deciding what the appropriate interpretation of statutory text is. So there's an ability on the part of a court to look to an administrative agency's interpretation of the statute, but there's no longer an obligation to defer to the administrative agency's interpretation of an ambiguous statute. And when a particular statute delegates authority to an agency consistent with constitutional limits, courts are obliged to respect that delegation. Obviously, courts still need to ensure that the agency acts within that delegation from Congress. Now, of course, we know in the tax area, this is something we're very familiar with. We're all used to reading congressional acts that provide a delegation of authority to Treasury to provide interpretive regulation. So the Chevron doctrine being overturned is obviously going to have an impact, but there will still be scope for Treasury to provide regulations clearly when they are given delegations of authority by the Congress. So the Chevron doctrine, we know, has applied much more broadly than just the tax area. Virtually all administrative agencies have engaged in rulemaking that may be impacted by the decision by the Supreme Court today. So for more details, read our insight. Thanks for watching. This has been PwC's Tax Insights in Brief.